Hello, everybody. This is the one I'm really excited about. Congratulations to your dad and to you. I'm really glad it sounds to have gone well. Hello, Nana Laura. By 5 minutes later than usual. I had to shower. It was non-negotiable. I know that's what I aim for. Hello, Mortimer Duke. Oh, by the way, even though you're snippy, hello, C-Rex. Hello, Catherine Gaston. Yes, everybody should sign up for Discord. Yeah, YouTube doesn't push mine out. I don't know why. I'm just not that special. I keep telling you guys that. I'm just not that special. No, they might have something to do with the time of night. 17. Thank you so much, Nana Laura. That's a long flipping dime. You guys are just chatting up a storm while I'm not here. When I logged on, it said there were 42 comments. I should have known it'd be the three of you. Hello, Marcotte. Hello, Manuel. Oh, I love your picture. I almost thought I had one of those earlier tonight when I was editing. Yep, I almost thought I was going to get to show you one. But alas, it was just somebody that was really ignorant. The latter. Hello, Joey Bag of Donuts. If I need to type, I'm here and you need to refresh. Oh my gosh, I love you guys. The greatest part of this, you guys choose to come hang out with me. There are people in my life that don't get to choose. I just magically appeared, like for my poor neighbor. He's great. And he takes everything in stride, and I love him dearly for it. So I went over yesterday to give him some jerky that I picked up from my hometown, because we, like, every time we find a new jerky, we gotta, swap it. So there's the Baraboo Meat Market, and they have this amazing jerky. And so when I was there, I noticed his wheelbarrow that he was so proud of. He put so much work into fixing it. He's a handyman. And he put so much work into fixing it. And not even a week or so ago, he had been teasing me about the bolts on my wheelbarrow were really loose. And of course, I didn't listen to him, didn't do anything about it. I still haven't used my wheelbarrow, so no sense in doing work until I need to. But I see his is not doing the greatest. It's not in the greatest shape. So when he was out mowing his yard, I called him, and he had to answer because he knows that I know that he has those super fancy AirPods, and I can hear him even with the lawnmower running. So no excuse. I'm watching you. Answer my call. So he picks it up, and he says, what's up? I'm like, so you got any big plans this weekend? He just kind of chuckles. And I said, I received a report that I had to contact you about. Apparently, you have a very distressed and defenseless person or female in your backyard. And the funniest part was he actually kind of looked around. And I said, yeah, she goes by the name Eileen Barrow. Eileen Barrow. And all of a sudden, the look that came over his face, he starts chuckling and he goes, you needed that, didn't you? Yeah, I really did. Made me feel so much better. He filled it full of too much sand, and apparently his bearings weren't tight enough, or his bolts weren't tight enough. And, yeah, it's now got a name. Oh, Will's sister. Well, I don't know where Wheel is. She she needs to join the party. I leaned over. I've not heard that one put together yet. I've heard Dover on a few other things. Oh, thank you so much, Joey. Thank you. Okay, I went into story mode and I stopped looking at chat because, you know, it was being dumb and not telling Joey that I was here. So I had to stall so that Joey had time to get in. Hello, Spider-Man. Hello, Army Brat 1964, sweetie. Hello, Sandy Hurd. I'm just grateful for you guys hanging out with me by choice. And I'm explaining, you know, what could happen if you had to deal with me in real life. Dad jokes aplenty. Eileen the screw loose. Wheelbarrow, brother of Clyde, made it big in the construction industry. Mike Oxnell is related to Oliver Closeoff. I can't say that one. That's the oldie but goodie. Late to every date, huh? It's all right. My brother had this really obnoxious friend, and my mom only had one eye. She had to have her eye removed in 1986, her left one. And this obnoxious redheaded brat of my brother's friends would always go up to my mom and go, "Hey, Melva, the one eye love." What a jerk. It was all in good fun. Mom took it well. Mine's not. Oh my gosh. I need to go take a picture of that wheelbarrow. Yeah, they like to linger after dinner. Oh my gosh, my stomach hurts. Did hoodoo. Yvonne! Hello, sweetie. We're just having fun. Glad to see you, love. Oh, now you guys are all officially like gutter brained. Not my fault. I just told a joke about a busted wheelbarrow. Y'all took it way, way too far. But we've got a cute case, and then we go to Connecticut. I don't know, Connecticut. And that's why you keep coming back. Love you. You were 22 and fresh out of the army in 86. I'm just going to leave that there. There we go. There we go. How do I say wheelbarrow in Maori? Oh, Sandy, thank you, sweetie. Bladder Issues by Dr. I.P. Freely. I farted so caught in a trap. Can't hold back. You know, there's some people that'll pay some pretty good money for those jars. No, I don't know from personal experience, but you'd be surprised what you see for ads on Craigslist. Oh, that's how you say wheelbarrow in Maori. Just wheelbarrow in Maori. Thanks. Couldn't have done it without you. All right, guys. Let's have some more fun. Let's see, we're going to start out with this one, and then I got one more after this.
June 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Thank you for your patience. My in-custody arraignments went a little bit longer than I anticipated. So my understanding is that the two of you should probably have a conversation in a breakout room to see if there is a number that you can get closer to or not.
So, Your Honor, I can tell you that Mr. Simpson's account, after all of the garnishment funds that have been received have been applied, his account's paid down to a total of $23.15. That is his total remaining balance.
Okay, then let me call the case.
Thank you.
Now calling 18C3959. This is Lake Point Trafalgar LP versus Craig Simpson. Can I have names for the record, please?
Good afternoon, Your Honor. Robert Visconti, P61756 for the plaintiff.
Okay, thank you. And Mr. Simpson, I'm going to send you a prompt to unmute. So just click that. Try again.
All right, there you go.
There we are. And say your name, please.
Craig Simpson.
Okay, thank you very much.
You're welcome.
So, okay. As you were saying before we officially called the case, Attorney Visconti, the balance remaining in this matter is how much?
$23.15, Your Honor.
15. Okay, so Mr. Simpson. How much time do you need to make that last payment?
Well, if I could just pay $25 a week, that would be like they take it out of my check every week, 25.
Okay.
And,
Well, he's saying that you only owe $23.15 at this point.
That's correct.
oh, that's all I own?
That's all
Yeah.
you owe.
Oh, well, shoot.
Okay.
I'm looking at, because it says right there on my paper, say I own $284. I don't know why they say anything about $23.
It takes a little bit of time, sir, for the payments that come from your employer to clear and then catch up and for the account to be reconciled. But as of your most recent payment, the remaining balance was $23.15. I'm sure.
I absolutely love Mr. Craig Simpson. His just joy and absolute shock when he found out he was down to one payment after he filed this motion to cease the garnishments. Like, that has to be an immense, overwhelming sense of pride right there. And he showed it. That was just glorious to see that on his face.
Sure that'll be taken care of by the next garnishment payment, and then we can go ahead and get the garn released. Okay, after it's paid.
Oh, okay. Okay, then that's fine. That's fine.
Okay.
I agree with that. Wow.
Excellent. Okay, so what I am going to do then, Mr. Simpson, this means I am going to deny your motion, but it's for a happier reason than they usually are. So there we go. Okay.
Well, at least
and
if I own $23, they can take it out of my net pay, and that should be done. Should they be able to send me a mail and let me know they done paying?
Yeah.
Oh, okay then.
Yeah.
Okay,
I
so
just
you
wanna
said the
make sure
remaining
it's not
balance,
gonna
just so that
what
I make
about
sure
my
that
job? They gonna let my job know to stop taking out of my check?
Yeah, so there after the next payment, or after the next garnishment payment, you will be paid current, and then we will release the garnishment and we'll refund any overage from that last payment,
Oh,
and
okay.
you'll be all set. Okay.
All righty. Thank you so much.
Okay.
Am I done?
And yes, Attorney Visconti, you said that the remaining balance is only $23.15, correct?
Correct, Judge.
Magistrate, but thank you.
It's a habit.
Yeah, that's fair. Okay, yes. So, Mr. Simpson, you are free to go. Attorney Visconti, if you don't have anything else, you are also free to sign out.
Thank you very much. Have a
then.
nice day.
How do I
Okay,
sign
thank you
out?
both.
I have somebody else show me how to do it.
Yes, here, I can help with that.
All right, then. Thank you.
Okay, thank you. Thank you for your patience. Now calling 24C6697. This is James Kearney versus Maynard's Automotive Service Center. Can I please have you unmute and state your names for the record?
Jeffrey Maynard.
James Kearney.
Okay, thank you. So today is the date and time set for a hearing in this matter. This is a small claims case. What I am seeing is that Mr. Kearney, you filed this. You are requesting $7,000 in damages from work that was completed on your truck in January of 2024. Is that correct?
Yes.
Okay. Thank you. Then before we get started, what I am going to let you know is that either of you do have the right to remove this to the general civil docket of the district court, where it could be heard by the judge and you could have attorneys at that point. If you continue in small claims, you are waiving the right to have a trial by jury. You are waiving the right to have an attorney. Ordinarily, you would also be waiving your right to appeal. However, because I am the magistrate, I will hear your case and make a decision. And if you decide to, you can appeal my decision and your case would be reheard by the judge anyway. You would, however, be waiving the right to appeal the judge's decision if you continue in small claims. So,
Judge.
what was that?
We're
Any
just
questions?
seeing, yeah, we're just seeing him in court.
We'll
Okay.
go to the judge. We'll see him in court.
Okay, so you would like to remove this to the general civil docket?
Yes.
Okay, that is your right. So, you will need to consult with an attorney then. I do believe there is something that you will need to file. Okay, I cannot give you any sort of legal advice, so you will have to look into that process. All right. Okay. Then that is, I will make a note of that and we will look for the paperwork. Okay.
Okay.
Sounds good.
Okay, thank you. Then this hearing is concluded and everyone is free to. Good afternoon. Now calling case number 24C6697. This is James Kearney versus Maynard's Automotive Service Center. Connected to audio. Let's try this again. You need to connect to audio. There we go. Okay, you should be able to hear me. Just sent you a prompt to unmute. And I just called the case 24C6697. This is James Kearney versus Maynard's Automotive Service Center. So can I have your name, please?
My name is Jeffrey Maynard.
Okay, thank you. And what is your relationship to Maynard's Automotive Service Center?
I'm the owner.
Okay, thank you. So we were last here, it looks like on March 20th of this year. Both sides appeared. At that time, the defendant, that being your side, I don't remember if it was you specifically, but you requested removal to the general civil docket, which is within your right to do, but then none of the paperwork that needed to be filed to actually do that was turned into the court. So we were here today for an entry of default hearing. However, the plaintiff has failed to appear.
So he
So-
came in, my bad, I'm not meaning to cut you off, Your Honor.
Yeah.
He came in to my establishment 2 days ago on a Tuesday, and he came in apologizing to me and saying I was right, I did the work right, and my employees, and he said he's not gonna show up today. That's what he told me.
Okay, well, the hearing was set for 2:15. I'm calling it now, it's about 2:45. And he has not appeared, so I am dismissing the matter without prejudice. So I will note that he could potentially appeal that within the next 7 days, but
Okay.
okay. So you will receive a copy of the dismissal in the mail. And I will also note that it being dismissed without prejudice does mean that he could conceivably file again. But okay, then if there's nothing further, you are free to sign out. Thank you.
Thank you.
All right, the court will call the case of Lloyds of Oak LLC versus Michelle Moncrief, case number 24C32.
Let's watch Judge Washington get a little irritated with counsel, because that's fun.
36.
Good morning, Your Honor. Taylor's Really P 87939 on behalf of Plaintiff Lords of Oak.
Thank you. Is Michelle Moncrief present?
No, she is not. So this is actually a motion to reinstate the case for the purposes of filing a default.
I'm familiar with that part. I wanted to know if she actually showed up here today. So I see that she has not. And I see that we sent a notice to dismiss, but it was returned to us. And let me try to see which one came back.
We received the dismissal, Your Honor. We just didn't receive the notice of intent to dismiss.
Motion to reinstate came back, and your notice of intent to dismiss never came back to us.
Trying to get it in on a technicality. All right. We've seen this before.
So I understand that you filed your action and you filed notice that they had been properly served, and then you did nothing.
So I joined into this case in early 2025. I believe it's just we were waiting on an answer because we personally served, and we were waiting on an answer. And obviously, had we received the notice of intent to dismiss, we would have more promptly filed the request for entry of default judgment. We're just asking, everything else was timely filed in this case, including our proof of service, our motion for second summons. We're just asking for equitable relief, seeing as we didn't have the intent to dismiss, and we filed this motion timely as well within the 21 days of dismissal.
So between December 29th of 2024, when you filed notice, they get 28 days to respond depending on the type of service, right? And you didn't do anything until April, when it was the notice of intent to dismiss was issued, and the case wasn't actually dismissed until last month.
Yes, Your Honor, that is the timeline.
What is your intent to litigate? There's no defendant. What is your next plan?
Our intent is to file a request for entry of default judgment against the defendant in the amount of $5,250 for the breach of contract claim. And apologize.
So please reopen the case so that we can default on the other party that didn't come today because all of their service was sent back to the court. That's something a lawyer might do.
I'm looking for the second count. It was conversion. That is our intent, to file a request for default for the amount for the specifically the breach of contract, and then we need a more exact amount for the conversion.
The address that you have for the defendant, and I don't want to put the whole address on the record, so please do not say the actual street, but is the number that you have, the 16544, accurate? Because the mail keeps coming back from that address as not a valid number.
That is the address that we sent this motion to. I believe that is the last known address, and that's where she was personally served. Let me see.
It was served at a different street and address. How we got this address?
I apologize, Your Honor. I don't have the proof of service in front of me. I can pull it.
I have the proof of service. It says she was served. That she was, well, actually the proof of service is not accurate. It doesn't say how she was served, whether it was personally, registered mail. The box isn't checked.
And there were, so I apologize, Your Honor. I don't have the proof of service in front of me, and it doesn't seem like my case management system is loading. So I suppose I will have to withdraw the motion if the proof of service doesn't have or isn't proper.
Yeah, the proof of service isn't proper. I'm denying the motion. The motion is denied.
Okay. Thank you, Your Honor.
Yeah, Judge Washington just wasn't at all annoyed with that. I love how she does always keep it professional for the most part, but you always can hear that tension in her voice and that very almost mom-like level of disappointment. Yeah, like, you don't make her mad. You make her disappointed. So drive faster and get out of there. Now would be the perfect time to put Manuel's joke up there. I didn't want to put it up during the case because then it would be on there for the replay crew minis and really confuse people. The flatulets. I pray I never hear them. I think Ava has been auditioning for them secretly for the last week and a half. Yes, she's been taking audition videos under my desk. I can't find the camera to take it away from her and tell her to stop doing it. So yeah, I just have to deal with the stench of dog farts regularly under my desk. Yeah, that's the mom thing to do right there. I'm very disappointed. No other context, just yeah, no. Who did the one in the last case? Or were you guys talking about something in chat and I totally missed it? I do that sometimes. All right. So the next ones are from Connecticut. And the only thing I'm going to say is the last hearing, the file, I don't want to use corrupt, but at some point the audio and video disconnected from reality and decided that they each were going to do their own thing. So they don't line up. I'm sorry, I did what I could, but it's only on the last one. But the content of it was good enough that I wasn't gonna not show it.
Good morning, Your Honor. We're now on the record.
Okay. Good morning, everyone. This is the matter of John McCarthy versus Director of Connecticut Valley Hospital. Would you identify for the record plaintiff first?
I'm John Joseph McCarthy.
Okay, Mr. McCarthy, thanks for coming in today.
Thank you.
Good morning, Your Honor. Alina Bricklin Goldstein, Assistant Attorney General on behalf of the respondent.
Okay, thank you. All right, Mr. McCarthy, this is a hearing on your motion to disqualify. You filed a motion to disqualify. You actually, it's docketed as a motion for order. It's at number 113 in our docket.
Line on here.
I'm sorry?
Go ahead. No, I'm with him. Yeah, go ahead.
Okay, so anyway, you say that you want to disqualify. You don't name the judge. You don't name the judge, but you entitle it motion to disqualify, motion for judge to disqualify. And you simply say that McCarthy moves pursuant to state and federal law for the present judge to disqualify. I'm going to hear this motion to disqualify. I don't know if it was your intention to apply it to me. I am Judge Edward Domnarski, or if you intended to apply it to another judge that has made rulings on the case.
I thought it was the last judge that I saw on the video.
Okay, was it? That
no,
may have been.
It wasn't you.
That may have been Judge Rupal Shah.
I don't know.
Female.
Yeah, that must have been her.
Okay. Just for purposes of identifying, was that a female judge?
Yeah, it was a female.
Okay, I think then it must have been Judge Rupel Shaw. Okay, so Mr. McCarthy, I am going to hear your claim of disqualification. Please tell me why you feel this Judge Rupel Shaw should be disqualified.
I want the Attorney General's office off of the case. It's my contention that they're deliberately mishandling this case, and also they're allowing the respondents to break the law. They broke the law already, and it's the Attorney General's responsibility to look into that or send it to the appropriate law enforcement agency. And instead, what they're doing is protecting these people. So I got that issue, and I also got that they're deliberately protracting the habeas corpus. So to keep me in here and defeats the purpose of habeas corpus. I mean, this habeas corpus is not going to be heard now for several months, and it's going to be over a year.
So let me make sure I understand, Mr. McCarthy. You mentioned the Attorney General's office. I don't know who you're referring. Are you referring to the defendant?
Respondent.
I mean, or the respondent?
Yeah.
Okay. Now, let me just also clarify. You previously had the court appointed counsel for you previously.
Yeah.
And then you stated you did not want that appointed counsel to represent you. Am I correct on that?
That's correct.
Okay. So you want to proceed without counsel?
Yeah.
Okay.
There's a basis for that too. I can afford counsel. So they wasn't supposed to represent me.
Well, okay. Well, for right now, to the extent you're making claims against the Attorney General's office, that's not really before me. What's before me is your claim that Judge Shaw should be disqualified from the case. So if you could focus on why you feel Judge Shaw should be disqualified from hearing this case, that would be helpful to me.
All right, because she's mishandling the case by allowing it to be dragged out. She's ignoring the rules. She's defeating the purpose of habeas corpus. Those are the reasons. It's prejudicial.
Okay. I think I understand your claim. Attorney Bricklin Goldstein.
Thank you, Your Honor. I don't take a position on Mr. McCarthy's motion. We don't have a basis upon which to formulate a position as to any rule breaking or protracting of the case.
Okay, thank you. All right. All right, Mr. McCarthy, is there anything else you want to say about on this particular matter?
Well, if that's it, if that's the only matter that's on the motion, I thought I had put more matters. I thought it was the Attorney General's office and it was the court and the Attorney General's office.
Can you do that? If the Attorney General is working on a case in place of the prosecutor, like they're representing the state, can you file a motion to have the Attorney General removed? Wouldn't it just be replaced with another Attorney General? Like someone from the office, or how would that work? I don't think you can do that, sir.
Which would have been this one.
Well,
right here.
again, you've made a motion to disqualify the judge in the case. That has nothing to do with the parties that are.
I thought I put both in.
Well, wait a second. In your motion for order number 113, it says motion for judge to disqualify from the case.
That's it.
And you only speak about your claims regarding the judge. There's nothing else about counsel for the defendants or respondents.
Respondents. All right. If that's what's there, then we'll just have to proceed on that. And it's what I said.
Okay.
the judge is allowing the case to be deliberately protracted. I feel it's prejudicial. It's going to be a year before it's heard. And I feel that defeats the purpose of habeas corpus. I don't have access to a law library here, so I can't research any of the state law to support any of my claims. So I'm just putting them out there, hoping Your Honor would know the law, and that's where it's going to go.
Okay.
So it's my contention that she's allowing it to go on and with no purpose, and she's allowing it to go on with no purpose, and allowing the respondent to file motions where they raise issues that are frivolous and are a waste of time. And this is just to defeat the purpose and to protect these people here.
Okay, well, again, Mr. McCarthy, you are the moving party here. You have the burden of proof with regard to your claims regarding the habeas corpus. I will note that there was a scheduling order that was proposed on April 7, 2025. That's number 110 in the docket, and that scheduling order was accepted by the court. Are you familiar with that scheduling order, Mr. McCarthy?
I don't believe I received it.
Well, I have a copy that you signed it.
The mail in here, what's the date on it?
The date of the scheduling order was April 7th, 2025.
You got them papers I gave you?
Yeah, but I don't have April 7th.
Let me look at them.
As far as the scheduling order, Your Honor, would that be something that's mailed to Mr. McCarthy? Because the way that it was left,
The papers, let me get them.
like that, it's just the one that you gave me.
All right, let me get that.
Well, I see his signature on it. I don't know if he kept a copy or not.
Most likely I did, but I want to see here.
That's May 7th. That's all I have as far as paperwork.
This was, there's one here for 5/19 of the court date. And there's one here for 6/9. That's today.
Well, I'm just looking at I appreciate that. I'm just looking at the date. All right. What I'm going to do, I'm going to have the clerk send a copy of the habeas scheduling order to you, Mr. McCarthy.
All right.
So would you do that for me, Kelly? That's number 110. And I do expect you to follow through with that. And let me just see something here. The case has been set down for a court trial on December 15, 2025.
That's the court's date.
That's the court's, there's a court trial scheduled on December 15, 2025.
Right.
Okay.
Don't worry about it.
Oh, yeah.
Again, Mr. McCarthy, I'm going to take this motion under advisement. I appreciate that you may think that habeas corpus is a rather simple matter, but I can tell you that it is a legal matter that has some issues related to it. I urge you to obtain counsel to proceed in this matter. Otherwise, the court will, proceed to take up the matter in due course.
Yeah, well, I'd rather that because I can't afford counsel. I have.
Well, you
money
had
to pay for-
the court was
No, I can't.
the court was prepared to appoint counsel to you.
Yeah, but if you give me counsel now, they're going to just drag it out, and I can't afford counsel, and that's an opposition.
You don't have to. If the court appoints counsel on your behalf, you do not have to pay for it.
I know,
and right now the case is scheduled for trial in December, so it's not going to happen before that. And frankly, if you're not ready, my point is you better be prepared to present your case in December. And if you don't have counsel and you don't do a good job presenting your case, who knows what's going to happen? I'm just saying that counsel. I don't think counsel are going to hurt you. I think they can only help you. But you've got to make the motion to get them.
No, I don't want, I'll take the case myself.
Okay, very good.
Thank you.
All right, we'll send you the scheduling order.
All right, thank
And,
you, Your Honor.
and I'm going to, right now, just so you know, there is a status conference scheduled on November 24th to discuss the status conference for the upcoming trial, which is scheduled for December 15th,
Yeah, I have that here.
2025.
I have
Okay.
that. Yeah,
You're aware that the case has been scheduled for trial?
yeah.
Very good. Okay.
I'm
All
aware
right.
of the trial and the status conference.
Yep. You got both? Okay.
I don't have access to a law library. I can't afford a lawyer. Well, yes, you did appoint me counsel, but it wasn't the counsel that I wanted. I'll just take the case myself. No, I don't know what habeas corpus entails. I can do this.
All right. Anything more on your motion to disqualify, Mr. McCarthy?
No, that's it. I raised it up about the judge.
Okay. I understand.
What you doing?
Okay. And just for the record, Attorney Brooklyn Goldstein, anything more?
No, Your Honor. I'll just inform the court. I anticipate filing a motion to dismiss probably later this week.
Okay, well, that's up to you. Anyway, in any event, I will take this matter under advisement. Thank you both.
Thank you.
Thank you.
Okay, that's it.
Yeah, but next.
And what's our next ready matter?
Our next ready matter is the Longbridge Financial LLC versus Elizabeth Stephen.
Good morning, Your Honor. Attorney Thomas Kusa, McCalla Raymer on behalf of the plaintiff, Longbridge Financial.
And good morning, Your Honor.
Good morning, Attorney Kusa. And for the defendant?
Good morning, Your Honor. This is Daniel Mara from Sandler and Mara for Ms. Steffen.
All right. Good morning, Attorney Mara. You're relatively new to the case.
Very new.
Yes. All right. What do you want me to know, Attorney Mara?
Your Honor, this is an 83-year-old woman who lives alone.
Well, first of all, this is your motion to, let me make it clear, this is your motion to open judgment and extend the sale date.
Correct.
Number 119 on our docket. Go ahead, Attorney Mara.
This is an 83-year-old woman who lives alone, who, well, appears to me responded calamitously to being served with this litigation and did nothing about it. She's on the eve of a sale date. She has not attempted mediation. She has not attempted reinstatement, although both are allowed. The mortgage, this is a reverse mortgage, where the reverse mortgage itself says that reinstatement is available even after foreclosure has commenced. I found out about this case really by happenstance. On a who said she was on the verge of losing her house. So I'm stepping in hopefully to provide some time for her to explore reinstatement and whatever benefits she may be entitled to or can get under the Emergency Mortgage Protection Program. I honestly don't know a lot about this case. I know it's proceeded about as quickly as a foreclosure can proceed. I know it's a reverse mortgage, and I know that my client has been served and stuck her head in the sand. But as a matter of equity, I don't see, as the equities go, that there should be an issue in extending the sale date to allow her to attempt to exercise the rights that are available to her under the mortgage.
That is a tough position for that lawyer to be in. When a client just does nothing and ignores everything up until the very last moment and then expects you to step in and save the day. Well, actually, she didn't even really expect him to. He said he came across this case by happenstance. So she was just going to let it all happen and not deal with it.
So again, to be clear, Attorney Mara, you're asking the court to open the judgment to give time? Is it for, and do you think you can do reinstatement without mediation, or do you think you need mediation along with reinstatement to get to reinstatement?
I think we probably need reinstatement with mediation, would be my guess. I have not had any discussion with anybody at McCalla-Rager. And I'm glad to see that Mr. Kusa is now identified with the file. My guess is that mediation would be helpful to get to reinstatement.
All right.
Your Honor, if I may.
Now, I'll give you a chance, Attorney Kusa. You know that. I'll give you a chance.
I know.
Thank you, Attorney Mara. Attorney Kusa.
Yes, Your Honor. My client really takes no position with regard to this, though I will, looking at the affidavit of debt, Your Honor, the taxes at time of judgment were $59,748.82. And of course, since we're getting very close to July, that number will be going up again. So as far as the possibility how to figure out a way out of this, as you say, whether it's some sort of state program, federal program. The only reason we went to a sale is because the United States is a party to this action. Otherwise, it would have gone to strict because we're already above the fair market value of the property. So we take no position, Your Honor, other than we just wish to make sure that if we're not exactly sure what's the best way out of this.
Yeah, I appreciate that. So, Attorney Kusa, with regard to these reverse mortgages, the tripwire is what, the payment of taxes and insurance?
Yes, the taxes and homeowners insurance must be maintained by the borrower, basically.
Okay. And that wasn't done in this case?
That's correct.
Now, did the mortgagee pay those taxes and insurance?
Yes.
And then that's added to the debt?
Yes.
And that also constitutes the default?
Yes, the non-payment, basically non-payment of taxes does constitute an event of default.
Yeah. So, Attorney Mara, I go through that for my benefit, but also for yours, because reverse mortgages are kind of an unusual instrument, as I've learned, having done foreclosures for a while. And I don't mean to, please forgive me if I offend. Are you familiar with reverse mortgages and how they work?
I am, Your Honor, yes.
Okay, so in view of the fact that we have these problems with ongoing payments, so to speak, do you still see a way here to save this property?
Well, one of the reasons why I think mediation might be helpful, Your Honor, is if the taxes outstanding are $50,000, the tax bill on this property for the last 3 years at least has been about $5,000. So I'm not sure what exactly the event of default was. And that's one of the things that I have to find out.
Yeah, well, I'll tell you that it may also be the insurance, which I know that forced place insurance can be very expensive also.
I'm sure it might be. The complaint says that he either failed to pay taxes or failed to pay insurance. So there's very little I can really find out about from the complaint. To be quite honest, Your Honor, I don't know if Ms. Steffen is going to be able to reinstate or not. I've asked her to pull together a bunch of her records, and within her capability, she's trying to do that. I am very new to the case, and I'm definitely trying to play catch up. But that's impossible to do with a sale date for next weekend.
Yeah.
So my hope is yes. I mean, if the event of default was the last tax payment or was the first tax payment missed, I don't know. Because $50,000 did not accumulate over the last 2 years or last year. So there's some questions that I have in my mind. But again, Your Honor, I don't really have enough background immediately in the case, really even to frame the argument at this point.
I understand. Attorney Kusa, he's right. This is a very recent case, having been brought in January. And I've also observed over the years that with reverse mortgage, it's sometimes not uncommon where the debt, for various reasons, far exceeds the appraised value of the property. I'm sure you're familiar with those cases too. And I say to myself, how does this happen? And then I learn, well, it's a reverse mortgage, and that's built into it, and there's insurance and other things, and federal insurance and other things involved. So I'll tell you, Attorney Kusa, under the circumstances where it's such a new case, since it is a reverse mortgage, since she does have counsel who's committed to at least attempting reinstatement, I'm inclined to grant relief. Having said that, I want to hear, again, I know you say no position, but again, if there's anything I've said, Attorney Kusa, that you want to add to or correct, please let me know.
Only with regard to, as you say, the taxes are going to go up unless, unless Ms. Steffen comes up with additional as funds to hand, which I'm assuming she doesn't, only because she hasn't paid previously. So as far as
those are some incredibly high taxes for a year or two. $59,000. That math doesn't math. I mean, my yearly taxes are a couple thousand. I don't understand how in Connecticut she could assume that much debt. And then on top of that $59,000 for taxes, there's the automatically instated homeowner's insurance, which is just essentially the highest amount that you could possibly have to pay. And it's forced on you. There's no way she could get it back with those numbers.
And the fact that as you say, we are currently, the debt is currently over and above, as you say, as I stated earlier, the taxes are $59,000, the insurance is $44,000, whether or not that's forced place insurance, or how that number got calculated. As you say, the numbers are getting very significant here, Your Honor. If there is a way out of here, great. We're all for that. But
and on the point, again, to my education, Attorney Mara mentions that there's a right of reinstatement under the mortgage. Have you had any experience with reinstatements on these reverse mortgages, Attorney Kusa?
Insofar as people, as you say, being able to, I have one in my file right now, as you say. Unfortunately, the primary borrower was recently put into a home because he has dementia. The wife basically was just exhausted, and so just let things slide. And so now the family is collecting funds on their own to bring them up, bring the numbers current. And so, as you say, I can certainly see how that happens. As far as a reinstatement, I don't know that I've ever, for a mediation of some sort, if, as you say, some sort of federal program, state program assisting with this, I have no experience with that, other than, as you say, just the family pooling resources to try to save the property.
Attorney Mara?
Your Honor, I think that's an attempt that my client is entitled to make. I can't say I know for a fact it's going to happen or that she'll be able to do it, but the documents do allow her to make that attempt.
Yeah. Okay. All right. What I'm going to do again, I am considering the unique factors involved in a reverse mortgage. I'm considering the fact that the plaintiff has commenced this action only in January of 2025 and went to judgment in April of 2025. And the fact that defendant is now represented by counsel, I am going to grant the motion to open judgment. Is it better here to extend the sale date or vacate judgment? Attorney Kusa, you want to be heard on that? I would at least give 90 days for mediation to see what happens. So how would you like to have the court proceed?
I would, at this time, Your Honor, I think we would prefer, as you say, if you wish to push the sale date out 90, 120 days. I think that's probably the best option at this
I
time.
like what you said. I like what you said about 120 days, Attorney Kusa. I credit you on that. I think that might be a good thing with the summer months coming up and so forth. So here we are on June. When's the sale date? June 14th?
Correct.
Yes, June 14th.
Yeah. All right, so what I'm going to do is I'm going to grant the motion to open judgment. I'm going to set the sale date for October 18th, 2025. And I'm also going to enter an order referring the matter to mediation at the court's direction. Kelly, I'll ask you to enter those orders. Attorney Kusa, it would be my understanding that if mediation is not productive and you know that there will not be a reinstatement well before October 18th, I would understand if you file a motion to modify the sale date. Attorney Mayor, I owe that to him if there's no chance here.
I certainly wouldn't argue otherwise, Your Honor.
Okay, so we'll leave it that way. Any questions about what we've done here today?
No, I think everything's fairly straightforward, Your Honor. Thank you.
All right. All right.
Thank you, Your Honor.
You're welcome. Good luck to both of you.
Thank you.
Court is now open and in session. The Honorable Edward S. Demnarski presiding. The matter before us is Portfolio Recovery Associates versus Roland Sinek. Good afternoon, Your Honor.
Good afternoon.
Yes, Roland Sinek.
Okay. Mr. Sinek, you filed a motion for modification of the wage execution. Let me ask you now, what is your understanding as to how much they want to take out now?
Your Honor, what I did is because when initially we went to court, since then I've researched certain things and I needed to get that case in front of the court again. So the last time I did the thing, I did the modification so I could get it in front of the court and explain to you. Because the last time when we were there, I gave some of the evidence I had, and you, I'm not sure if it was you or the judge lift off the execution. And all of a sudden I got a letter from Mr. Cohen to the court stating that he had lost or misplaced it. Not that the judge had asked him on court records, he had turned it off. He had lost and misplaced it, and he sent it back to my employer. Since then, I've sent Mr. Cohen a formal letter because I did my due diligence, I did my research. I sent him a formal letter, which I submitted a copy to the clerk so you could have it. Did you ever receive that letter?
You know what? Take a minute. Hold on. Attorney Bukowski, can you give some guidance here?
Yes, Your Honor. A default judgment entered in this matter back on December 26, 2019. Then, of course, COVID intervened. And since that time, there have been a couple, apparently, of executions issued.
Let me stop you right there, Attorney Bukowski, because I have a case history here that indicates on December 17, 2024, I conducted a hearing on a motion for exemption of execution. That was number 107. And the notes from the clerk indicate that we completed that event and the plaintiff was to withdraw the execution.
Your Honor, I have to apologize. I was looking at the docket sheet in this. I did not see that in the docket sheet.
Uh-oh. The plaintiff was supposed to withdraw the motion and they never did? Whoopsie.
Was that the court's order of November?
Well, it could have been something, because I'm not so sure I have an order on it, but it could be.
Your Honor, like I said, I received a letter he sent to the court saying that
Wait a second. Wait, Mr. Sinek, give me a chance here, okay?
Okay, sir. Sorry about that.
Attorney Bukowski, if you look at 107.55.
Okay, I'm doing that, Judge. I see that.
I wouldn't have entered a note, I wouldn't have entered an order like that following a hearing unless that's what was said on the record.
I understand. I don't quite know how to respond to that right now, Your Honor. My instructions were simply to object to the motion for modification. I will be honest with you, Judge. I just saw on the docket sheet the designation and order for off. I did not read it.
Well, it was marked off because of the representations made at the hearing, for which I thankfully memorialized in that order.
I can see that in the document, Your Honor.
So how, so it looks like somebody started this all over again.
It looks that way.
Excuse me.
So let me do it. Let me find out another way, Attorney Bukowski. So, Mr. Cenac, as I've said on the record, it appears that we had a meeting back in December 17th, and you were present. And I don't have an exact recollection what was said, but I did say in my order that that your motion for exemption from execution back then was marked off because plaintiff's counsel said to the court, "Will withdraw the execution," and it's possible that they agreed to withdraw the execution because of what you said at that hearing back on December 17th. So let me ask you, accepting that that was what happened back in December, what do you think you tell me what has happened since then and your understanding of the proceedings?
You talking to me, referring to me?
Yes, I am, Mr. Cenac.
Remember at that time, Your Honor, I don't know if the court records have it, I expressed to you that at that time, like that date is from like 9 years ago, where I lost my job. I used to work in the state of Connecticut, and to tell you the truth, that was when my state card was thing in 2014. No, let me see, in September 9, 2015.
Mr. Cenac, let me ask you to focus. I think after that hearing, what happened to your knowledge about their efforts after that hearing?
I tried reaching out to Mr. Cohen. I guess he's very busy in New York, and I never heard from him again.
Who is Mr. Cohen?
Remember, we exchanged numbers at the hearing, and I was to call him. At the hearing, we did exchange numbers.
Okay. And so what did you think was going to happen after that hearing we had in December? What did you think was going to happen?
I wanted to call Mr. Cohen and explain to me how long that debt has been and if it's actually mine, because like I tell you, it is nine years ago. That's a long time ago.
Okay. Do you know of a Mr. Thank you, Mr. Cenac. Attorney Bukowski, do you know of a Mr. Cohen or Attorney Cohen?
Yes, Your Honor. He has appeared in this case prior to my appearance. I appeared in addition to him. I appeared basically for the purpose of attending this hearing.
So is Mr. Cohen, Attorney Cohen, admitted in Connecticut? I presume he is.
Yes, he is.
So it's very likely that he appeared at this hearing that we had in December.
If Your Honor's notes are correct, which I certainly believe they are, he must have appeared. I can't say.
Do you have some sort of, do you talk with him? Is it possible for you to understand what his position is on this regarding this matter?
I can talk
in view of what's happened here.
I can talk to the client.
You don't want to talk to Attorney Cohen? He's the one who said he was going to, he was the one who said he was going to withdraw the execution.
I can talk to Attorney Cohen, yes.
Um,
I don't know if there are representations made. Perhaps Mr. Senac could shed light on this. And because of if Attorney Cohen said he was going to withdraw the execution, I would assume Mr. Senac must have agreed to some type of payment arrangement of some kind. Could the court ask Mr. Senac that?
Yeah. Mr. Senac, see, it appears that the execution where they were taking money out of your pay was going to be withdrawn, but that doesn't necessarily mean the case was over. I think there was some expectation that you were going to talk to Attorney Cohen.
Well, like I said, other thing we exchanged numbers, and you said we have to figure it out. We exchanged numbers, but Mr. Cohen is, I don't know, he's very busy. He's in New York. He's very difficult. Even the time of the hearing, he wasn't there on time. He's a very busy man to get. And then, I mean, I trying to call him. He never answered me. He never returned my call.
So, Mr. Senac, are you willing to pay $20 a week?
Your Honor, yes, I am willing if that debt hasn't passed the statute of limitation.
Well, it's gone to judgment already. You see, that's it already's gone to judgment. So the statute of limitations is finished business. It's gone to judgment. Okay?
And then I guess the $20, I don't have a choice because anyway, it's pointless now saying that because like I said, I've been employed for the same place for the last 6 years. And that's why when all happened, I never got a chance. He couldn't find me for the 6 years. I've been working the same place for the past 6 years.
Yeah.
And he never made an effort to find me because that's how they do it. They compound the interest. And now I have 3 different amounts. When I get said, now they're trying to take $11,000 from me.
Yeah, that's with the interest. Yeah. So Attorney Bukowski, in view of the history here, and Mr. Senac's involvement, it's put you in a difficult position. I'm considering granting the modification to allow $20 a week. You'll get an execution. But I'm considering that. You tell me how you think I should proceed with this rather unusual situation.
Well, Judge, actually, the original judgment did contain a minimum, $35.
Yeah, that's our standard. Yep.
Yeah, which apparently wasn't complied with. I guess, Judge, as I said, I don't have personal knowledge of what Attorney Cohen may or may not have said. I'm going to assume it's correct that he said he was going to withdraw that. I have to believe he must have had in mind some type of alternate, maybe some type of weekly payment arrangement at that time. Unfortunately, if that's the case, I'm not aware of it. I can become aware of it. I certainly wouldn't want to waste the court's time by having to come back here again. For example.
It's been my experience, Attorney Bukowski, in these collection matters that, the plaintiffs are generally satisfied with an execution, even when they understand the circumstances from the debtor. Mr. Senac, could you do 35 a week?
35 a week. Your Honor, I work with FedEx, and it depends on the amount of packages I deliver. I get paid. Peak time, I might average $900 a week. When it's slow, it might be lower. Like I told you, I have two toddlers. I have a daughter in college. I have insurance. It'll be extremely thing on me. I mean, I could the 20. I guess I do have a choice because he said since it went to judgment already, all of the points I'm bringing is irrelevant now. But my thing is, I've lived in the same place for over 7 years. I've worked at the same place for over 6 years, and they never found me to serve it to me. I haven't moved. I haven't gone anywhere.
I hear you. I know that, but I can't change that. So why don't you go back to the very first question I asked you? How much do they want to take out under the present execution? Do you know the amount that they want to?
My salary, which was like $250.
How much?
Like $250.
All right. So frankly, if they want to take out 200.
Well,
You know,
actually, Your Honor, the execution actually was looking for $6,267.
Yeah. Well,
I could live with that.
So you could live with what?
We paid the $6,000 and paying it. I just don't want to make situations more difficult than me, because the job I have, I don't have a steady pay, Your Honor. The more I deliver, the more I get paid, the less I deliver. And you know, people order more stuff different times. I'm a delivery driver for FedEx. That's what I do.
It sounds like an opportunity. Take more deliveries, make more money. I mean, heck, if I got paid on pick rate per piece, I'd be busting butt.
Attorney Bukowski, would you like to make a proposal here under all of the circumstances?
Well, if Your Honor modify this.
Yes, I'm inclined to modify, but I do want to give you the chance to be heard. I know we talked originally about.
Well, Your Honor, as I said, my instructions were to proceed to attempt to object to any modification discretion. Well, then, of course.
Okay, fair enough. All right. I can go below the weekly order of $35 a week, and frankly, you're doing.
Okay, that's fine.
Attorney Bukowski, I'm
agree to it. It says there 5% or $35. That's what they were asking for.
Yeah.
Now he sent me something in December 24. That's dated December 26, 2019. Had I got it in 2019, I probably was a better situation. I would agree to the $45 in 2019.
Yeah, he's referring to the original notice of judgment, Attorney Bukowski, at 102.10, provided a weekly order of $35 a week. That was the original order, yeah.
That's correct, yeah.
That's at 10, because that's 102.10. Mr. Senak, Attorney Bukowski, under the circumstances, I'm inclined to modify to $35 a week. Do you want to be heard further on that, Attorney Bukowski?
No, Your Honor.
Mr. Senak.
I see you learn the hard way. I understand. Had I found everything before it went to judgment, it wouldn't gone, because that is from 2015. But like you said, it already went to judgment, and there's nothing I could do with it at that point. So I have to.
So I'm going to enter an order that the execution is modified to $35.
When would those payments start, Your Honor?
Well, again, it's an execution. So are you going to proceed under the execution? If you are, it comes out of his pay and you pay the marshal. Why? You want to do direct payments?
No, Your Honor.
Or, it's his motion to modify an execution. You want to withdraw the execution and have, direct payments? You can do it that way. There's an execution in place now.
The marshal back there every week?
Attorney Bukowski, that's above my pay grade. I don't handle that aspect of it, okay?
Yeah.
I can enter an order as to what the execution will be. I don't manage the details. Right. All I'm doing is modifying the execution to $35 a week.
Yeah, right.
Okay. So, and Mr. Senak, what I've heard is that if you came into some money and a lump sum payment, and you wanted to make a lump sum.
So much hardship to me.
Sorry, please.
I said, and I appreciate the $45. I think I will have to stay home.
Yeah.
Your Honor, I'm sorry to interrupt. I just want to bring to your attention that on the execution, no employer is listed. I know that he did mention FedEx, but I just wanted to bring it to your attention.
It's Dreaming Green. She already had something. So as soon as I give me a letter, I could take it to her. She already had the original one. They sent it to her already.
So you must have already hit an employer. Thank you for bringing that to my attention,
Yes,
Kelly.
she had it. She was the one. She was the one who brought it to my attention. I didn't even know that. I didn't get it. She got it.
And that's where it cuts off. It was on the border of, is it too flawed for me to run it? Because, you know, the internet's full of hate, you know. You put something out there that isn't perfect, and you got a bunch of people in the comments that are like, at, you know, minute marker, this, you know, the video glitches. So I really was hesitant on this one, but it made me laugh, especially Chester Bukowski. I couldn't get enough of his dopey expressions. And the curtain situation that we've got going on. So it's multi-layer, it's multi-level. We have, I'm certain, the standard blinds are the first level, and then we have the curtain. There's, I think the blue one is supposed to be, what do they call that, a valance? But there's a curtain and an under curtain. I mean, they went all out on that. What? No, no, we're just talking curtains right now. The other thing, the 4, I've seen that before. That's a lamp. That is a lamp. They sell it at Walmart. I've seen that. Well, that kind of happened a few times. Squishy. Well, yeah, I know. That was one of the reasons that I started editing for him in the first place. You know, back when I got my start. I was bothered because I couldn't stand seeing phone numbers and addresses not removed or not even attempted to be removed. That bothered me a lot. And I was like, well, heck, I might as well learn to edit myself, and then I can take them out of there and share them with everybody. And so that was, you know, that was how I got started. I'm glad I got into it though. Oh, I love you, Z-Rex. I hope you sleep well. I don't know. Are you going to be able to go to sleep? We've been laughing, having a hoot of a time. So happy to have you here. You can drift off to sweet slumber. Because I came on at the appropriate time tonight. Whoa, 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 whoa. Where do I get sex curtains? Mine are clearly not doing it. I mean, mine are blackout curtains. Skunks are farting kitties. Walmart, here I come. I get a kick out of whenever I'm putting in my order, it'll have the "Did you forget something?" And you know how unnerving it is when an adult toy product shows up in your suggestions list on your Walmart order? I'm like, at first I was like, I did not know Walmart had. Oh wait, yes I did. They actually have them in store now. I have not, gotten any, but for that to show up in my suggested list of items. Oh no. Oh, sleep well, Yvonne, sleep well, my love. Okay, guys. Thank you so much for coming and hanging out with me. This is a blast. This is an absolute blast. And, 2 videos where the audio and video were wonky, and we still had the greatest time ever. Oh yeah. Yeah. With the latest accusations, especially. Yeah, like there's people are dumping their Walmart stock in droves, like can't get to that button fast enough, from what I hear. Yeah, that'd be appreciated. All that YouTube-y stuff, the like button, that subscribe, the bell, become a member if you want, all that fun stuff. I definitely appreciate it. And so does Ava, because, it mostly goes for the animals. You guys know that. We got Earl right there. Ava's on the bed. Tiny Kitten's outside. I think Billy's outside as well. Tiny Kitten and Billy are they came to me feral. So they zip out, and I just don't have the ability to catch them. So I now have 2 indoor-outdoor cats and 2 strictly indoor cats. But they stay in the yard, so I can't be too mad at them. And they've got their flea and heartworm treatment, and I deworm them quarterly. So he always has. He always has. He's so perfect. Oh, I hope that's just, the way that it seems, and that's not the true reality of it. It can be hard being a YouTuber, but like, I don't hold it against someone if they're here, like, that'd be silly of me. Just because, I mean, not you in general, but just because someone doesn't have a membership, or, just because, what, why would I, I can't think of the word, like, ostracize them for that. Just, silly. because I'd much rather have you here and interacting. The chat is the best part of all of the videos. You guys keep everybody laughing. And I can be funny, but I'm not a solo funniest. I work better like having someone to work off of. So you guys make this possible for me. Paid membership or not. I just want you here. And I appreciate you because I couldn't do this without you. And I really do love every one of you. So thank you again. And I hope I get to see you all real soon. Sorry, I've got dry mouth. My doctor started me on a new antibiotic. I've got new antihistamines. I'm trying. I'm sorry. It's like everything's drying. My sinus is out now because I've been so sick, but I'm getting better. Manuel, honey, I understand. Don't worry about it. Just be here. Be safe, be well, sleep sweet, and much love.